Hello everybody, Andrew Reed here, part 12 of my study guide for the upcoming NCA exam on constitutional law. And in this part, we're taking a look at the Notwithstanding Clause. So I'm just following along with the syllabus here for the NCA exam. I'm case briefing the hyperlinks therein. And this is just my personal study guide, and you're more than welcome to follow along. Let's go ahead and dive in with part 12, the Notwithstanding Clause. So this clause, section 33 of the Constitution, says the Parliament or the legislator of a province may expressly declare in an act of Parliament or of the legislator, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in section 2 or subsection 7 to 15 of the Charter. So there's an operation of exception that by invoking this clause, then the Charter writes, then it's okay to make this act an exception to the Charter rights. There's a 5-year limitation that it will expire after 5 years unless they reenact it. So the case cited here is Ford v. Quebec, but it's limited to paragraphs 23 through 36. The issue in this case being is section 58 or section 69 of a particular act called the Charter of the French Language. Is it protected from the application of section 2B of the Canadian Charter of Rights and Freedoms by a valid and applicable override provision enacted in conformity with the section 33 of the Canadian Charter? So really they're looking at what do they need to put in the act to actually validly enact the Notwithstanding Clause. So the override provision reads like this. This act shall operate notwithstanding the provisions of sections 2 and 7 to 15 of the Constitution Act 1982. In this particular case, it went before the Superior Court. They said basically that you don't have to get specific with this, just that saying that notwithstanding clause will cover you, and that's all you really need to have. But went to the Court of Appeal, who overturned it and said they feel like it should be required that a reference to what rights and freedoms that are going to be overturned is listed in there. In the Supreme Court, though, it says the requirement of an apparent link or relationship between the overriding act and the guaranteed rights or freedoms to be overridden requires that the legislator identify the provisions of the act in question which might otherwise infringe specified guaranteed rights or freedoms. So the court doesn't think the legislator is even capable of that, but they say even if so, that would seem to require prima facie justification of the decision to exercise the override authority rather than merely a certain formal expression of it. But there's nothing in section 33 that says they have to do all that, so overturned by the Supreme Court. The override declaration must be an express declaration that an act or provision of the act shall operate notwithstanding a provision included in section 2 or subsection 715 of the Charter. So although the Supreme Court had great respect for the view of the Court of Appeal and that politicians should be held accountable and should list the rights and freedoms that did make sense as an argument to them, the Supreme Court said nonetheless, section 33 declaration is sufficiently express if it refers to the number of the section, subsection, or paragraph of the Charter which contains the provision or provisions to be overridden. So in this case, they said the act to amend the Charter was valid and subsisting exercise of the override authority conferred by section 33 of the Canadian Charter of Rights and Freedoms. So ends section 12, part 12 of the study guide. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.